Hey everyone, welcome to Localism, the podcast that asks if we're putting our power in the right places. I'm your resident guy who thinks Snickers bars are overrated and host of the show, Bluntschli. In today's episode, the Cooley Doctrine and how that rule is based on a very different vision of local authority than the one implicated by the Dillon Rule and Home Rule. This is the longest episode so far, so settle in and get that 2x speed button ready. To kind of sum up from last time, we talked about something called the Home Rule that's used in a small but politically diverse minority of American states. Under that Home Rule, local governments can have some small amounts of inherent authority, either because they can do something like amend their own charters or because they can pass laws on local affairs that the state legislature may not be able to preempt. We also talked about how the space provided by Home Rule was better than the strict requirements of the Dillon Rule, but that ultimately Home Rule didn't actually provide very much local agency, as in some states, Home Rule doesn't change the ability of the state legislature to pass laws that completely preempt local laws, and in other states, the amount of stuff that counts as a local instead of statewide matter is very small. At the end of the day, Home Rule is just the shinier of two turds, and doesn't significantly alter the basic irrational and unjust dynamic at the core of the relationship between state and local governments. That dynamic is that local governments are closest and most responsive to their constituents as compared to any other level of American government, but have the least amount of power to try and take on those constituents' problems. Now we're going to talk about what I, in a perspective that I think is not shared by most people that look at this kind of thing, consider to be a third rule or third understanding that is distinct from both the Dillon Rule and the Home Rule. This is the Cooley Doctrine. And as we'll see, while the vision laid out by the Cooley Doctrine arguably lays out the groundwork for a much broader conception of local government authority than what's allowed in the Dillon Rule or Home Rule, I'll try to convince you that it still doesn't quite go as far as good sense and justice would require. Let's get into it. Like Judge Dillon, Judge Cooley laid out his rule, his Cooley Doctrine, in a late 1800s case that raised thought-provoking questions about how the state and local government should be related to one another. Unlike Dillon, the Cooley Doctrine has never enjoyed wide adoption. Or at least that's what I'm going to argue. Some might disagree for reasons we'll get into in a bit. So it's August of 1871, and big things are happening in the city of Detroit, Michigan. The Michigan State Legislature has just passed a law that creates a new Board of Public Works in Detroit. The job of this Board of Public Works is to handle stuff like fixing roads, managing water systems, keeping the sewers working, basic stuff like that. In the course of passing this law, the state legislature also names people to serve on this Board of Public Works. Well, it turns out that Detroit actually has a bunch of city-created boards that do the same stuff as the state-created Board of Public Works. There are members of the Board of Water Commissioners and the Board of Sewer Commissioners, both of which are created by the city, who are pretty pissed about losing their jobs. So the state and the local boards end up fighting with one another over who actually has the authority to handle water and sewage stuff in Detroit. Is it the locally created commissions or the state-created ones? Who gets to keep their jobs? Really, the big question in this case is, who should get to decide what local government agencies exist, and who gets to choose the people to run those agencies? Should the local government get to decide for itself, or should that be reserved to the state? I note that I wasn't able to find exactly why the state legislature decided to pass this law creating a new Board of Public Works. Maybe it was that the state legislature wanted to reward some lobbyists or donors with cushy public servant jobs. Maybe it was that the people in the locally created boards were corrupt and doing a bad job, and the state legislature just wanted to make things better in Detroit by installing new officials. Maybe it was genuine misunderstanding or confusion over how all this stuff worked and whether Detroit needed someone to take care of public works. This stuff is pretty complicated. It's not necessarily the case that this was some power grab by the state. In any event, the members of the city-made sewage and water boards get sued in quo warranto, hopefully I'm saying that right, a Latin phrase meaning what warrant. It's basically a way to sue a public officer and ask, hey, what power do you have to hold your office? And the case goes all the way up to the state Supreme Court. And it turns out that the members of the state-created board win. In late 1871, the Michigan Supreme Court rules in favor of the state board in the case of the People v. Hurlbut. The opinion considered and rejected several arguments for why the law making the state-created Board of Public Works was unconstitutional under the Michigan State Constitution. But it isn't actually the main opinion we care about. It's actually a concurrence in People v. Hurlbut that was written by our good friend Judge Cooley. A concurrence is what judges write when they agree with the outcome of the case, but have a different reasoning for why that outcome is warranted. Cooley's concurrence is what gave birth to Cooley's Doctrine. So what's in this big famous concurrence? Well, Judge Cooley starts out by engaging a bit with the majority rationale. Where he really gets going, though, is a section where he decided to write about local authority and the relationship between state and local governments. I'm going to do a lot of direct quoting from this section, so let's jump right in. Cooley said that the People v. Hurlbut involved, quote, a question of the highest interest and concern which cannot be answered without a careful scrutiny of the structure of our government and an examination of the principles which underlie free institutions in America. We have before us a legislative act creating for the city of Detroit a new board, which is to exercise a considerable share of the authority usually possessed by officers locally chosen, to have general charge of the city buildings, property, and local conveniences, to make contracts for public works on behalf of the city, and to do many things of a legislative character which generally the Common Council of Cities alone is authorized to do. The legislature has created this board, and it has appointed its members, and both the one and the other have been done under a claim of right which, unless I wholly misunderstand it, would justify that body in taking to itself the entire and exclusive government of the city, and the appointment of all its officers, excepting only the judicial, for which, by the Constitution, other provision is expressly made. Jumping in here briefly, there was a provision in the then current Michigan State Constitution that said local judicial officials had to be elected at the local level. Okay, back to the quote. And the question, broadly and nakedly stated, can be nothing short of this: whether local self-government in this state is or is not a mere privilege conceded by the legislature in its discretion and which may be withdrawn at any time at pleasure. Whoa, okay, so Cooley comes out blazing, saying this isn't just some question of who gets to handle sewage in Detroit. It's really a fundamental question about the nature of local government in Michigan and America as a whole. In fact, given that reference of whether local authority is something, quote, conceded by the legislature in its discretion, Cooley is, in so many words, saying that the case is really about whether the Dillon rule is right or not. And he acknowledges this pretty directly a little later on. Quote, the judicial decisions and law writers, read Judge Dillon, generally assert that the state creates the municipal bodies, endows them with such of the functions of corporate life, and entrusts them with such share in the local government as to the legislative judgment shall seem best, that it controls and regulates their action while they exist, subjects them to such changes as public policy may dictate, and abolishes them at discretion. In short, that the corporate entities are mere agencies which the state employs for the convenience of government, clothing them for the time being with a portion of its sovereignty, but recalling the whole or any part thereof whenever the necessity or usefulness of the delegation is no longer apparent. This I understand to be the accepted theory of the state constitutional law as regards the municipal governments. That's a flowery but honestly pretty damn good summary of the theory behind the Dillon rule. The reason Judge Cooley is describing the Dillon rule so accurately is that he's about to challenge it, and specifically challenge the assumptions that underlie it. Quote, and this is a really long one, but it's amazing stuff, and I want to give you all of it. If, therefore, no restraints are imposed upon legislative discretion beyond those specifically stated in the state constitution, the township and county government of any portion of the state might be abolished, and the people might be subjected to the rule of commissions appointed at the capital. The people of such portion might thus be kept in a state of pupilage and dependence to any extent, and for any period of time the state might choose. The doctrine that within any general grant of legislative power by the Constitution there can be found authority thus to take from the people the management of their local concern, and the choice, directly or indirectly, of their local officers, if practically asserted, would be somewhat startling to our people, and would be likely to lead hereafter to a more careful scrutiny of the charters of government framed by them, lest sometime, by an inadvertent use of words, they might be found to have conferred upon some agency of their own the legal authority to take away their liberties altogether. If we look into the several state constitutions, i.e. state constitutions in other states, to see what verbal restrictions have heretofore placed on a legislative authority in this regard, We shall find them very few and simple. We have taken great pains to surround the life, liberty, and property of the individual with guarantees, but we have not, as a general thing, guarded local government with similar protections. We must assume either an intention that the legislative control should be constant and absolute, or, on the other hand, that there are certain fundamental principles in our general framework of government which are within the contemplation of the people when they agree upon the written charter, subject to which the delegations of authority to the several departments of government have been made. That this last is the case appears to me too plain for serious controversy. The implied restrictions upon the power of the legislature as regards local government, though their limits may not be so plainly defined as express provisions might have made them, are nevertheless equally imperative in character, and whenever we find ourselves clear within them, we have no alternative but to bow to their authority. Let's try to decode this extremely long and comma-filled quotation. So Cooley is starting out by expressing a concern that if we treat the Dillon rule as correct, then we end up in this situation where there is practically no local rule, no actual decision-making being made in local governments, and instead everything is practically handled by the state. Then he comments that when you look at state constitutions, they provide lots of explicit protections for personal liberties, stuff like freedom of speech, right to bear arms, but don't really explicitly provide similar protections for local government authority. He then says, well, there's two reasons that might be. First, it could be that the intent for those ratifying state constitutions really was that the state-level government should just control everything. But he rejects that idea as facially ridiculous and unjust. Second, and this is the interesting one, that the reason there's no explicit protections for local authority in state constitutions is because there was no need to put them there. Instead, those protections are so fundamental to the general framework of the American system that they go without saying. It's so obvious they apply that it was unnecessary to outline them in the state constitution. That's a pretty bombshell take, this idea that there are background principles inherent to American law and American state constitutional law that provide protections for local rule. So what might those background principles be? Well, that's a good question. Cooley doesn't really describe them in detail, but he does explain why he thinks those principles exist. As he puts it, quote, the circumstances from which these implications arise are, first, that the Constitution has been adopted in view of a system of local government well understood and tolerably uniform in character, existing from the very earliest settlement of the country, never for a moment suspended or displaced, and the continued existence of which is assumed. And second, that the liberties of the people have generally been supposed to spring and be dependent upon that system. Judge Cooley then goes on to consider the history of several of the eastern states, specifically Massachusetts, Connecticut, Rhode Island, Vermont, New Jersey, and Maryland. He argues that in these states, it isn't true that the state government came around first and then organized itself internally to make these smaller local governments by handing down some power from above. Instead, it was the opposite. The local governments either predated the state government or sprang up simultaneously alongside the state-level government in separate but parallel development. He cites this really great passage from de Tocqueville's Democracy in America. De Tocqueville was this French guy who came to visit America after the Revolution and wrote a book about his visit, which was called Democracy in America and was published in 1835. It's a very influential book in American history and covers all kinds of topics that we don't have time to get into now. But as relevant here, Cooley suggests that de Tocqueville essentially saw the American system of government as being premised on local governments, and contrasted that to the French system of government that was all about centralization and one overarching government. Cooley looks at these histories of eastern states and how the state governments may not have actually come about before local governments, and ends up with this conclusion, quote, it is not the accepted theory that the states have received delegations of power from independent towns, but the theory is, on the other hand, that the state governments precede the local, create the latter with corporate life. But historically, it is as difficult to prove this theory as it would be to demonstrate that the origin of government is in compact, or that title to property comes from occupancy. The historical fact is that local governments universally, in this country were either simultaneous with or preceded the more central authority. Do you see what he's doing here? He's rejecting the historical premise that underlies the Dillon Rule and also, to an extent, the Home Rule. Cooley is flirting with a very different and very powerful idea that the states owe their existence due to delegations from local governments, that local governments gave the states life by delegating them some power rather than the other way around. This is basically saying that states are like mini Americas, that they came about when a bunch of local governments got together to give some power to an overarching government for the good of all. You might remember that in an episode or two back, I raised this principle as the most intuitive conceit for how states came to be, even though it turns out not to be the one that American law generally recognizes. And what's the consequence of this idea that local governments have inherent power, and that they exercise that inherent power to create the states instead of the other way around? Quote, "Constitutional freedom means something more than liberty permitted. It consists in the civil and political rights which are absolutely guaranteed, assured, and guarded. In one's liberties as a man and a citizen, his right to vote, his right to hold office, his right to worship God according to the dictates of his own conscience, his equality with all others who are his fellow citizens, all these guarded and protected and not held at the mercy and discretion of any one man or of any particular majority. If these are not now the absolute rights of the people of Michigan, they may be allowed more liberty of action and more privileges, but they are little nearer to constitutional freedom than Europe was when an imperial city sent out consuls to govern it. The men who framed our institutions have not so understood the facts. With them it has been an axiom that our system was one of checks and balances, that each department of the government was a check upon the other, and each grade of government upon the rest. And they have never questioned or doubted that the corporators in each municipality were exercising their franchises under the protection of certain fundamental principles which no power in the state could override or disregard. The state may mold local institutions according to its views of policy or expediency, but local government is a matter of absolute right, and the state cannot take it away. It would be the boldest mockery to speak of a city as possessing municipal liberty, where the state not only shaped its government, but at discretion sent in its own agents to administer it, or to call that system one of constitutional freedom, under which it should be equally admissible to allow the people full control in their local affairs, or no control at all. To clean up, what does this mean for the basic question of this case? What does Cooley think should happen with these competing public works boards, some created by the state, others created by the local Detroit government? Surprisingly, given how much time he just spent waxing poetic about the inherent right of self-government and municipal liberty, Cooley actually rules in favor of the state-created board. It is a concurrence. He's agreeing with the majority's conclusion, which was that the state government had the ability to create these boards and that the local government couldn't do anything about it. In deciding that the state government is right, Cooley says, "I have no doubt it was entirely competent for the legislature to abolish the old local boards and provide for a new one to take the place of all. That would be but the ordinary exercise of legislative supervision and control in matters of municipal regulation. I think also that the legislature might make provisional appointments to put the new system in operation. The right to do this appears to me to be incident to the right to confer and recall corporate power." And he adds, "There is no doubt of the right of the state to do any of these things, not by virtue of any general authority to take to itself the management of the local concerns, but because the inauguration and modification of local government can only be provided for without confusion and injustice by the aid of the guiding and assisting hand of the authority that creates and modifies. The right in the state is a right, not to run and operate the machinery of local government, but to provide for and put it in motion." So basically, even though states can't run or control local governments, they are still the ones that create local governments and set the scope of their authority. And out of that power to create comes the power to do things like create new municipal boards. So to Cooley, the Michigan State Legislature had the ability to create a new public works board and get rid of the locally created boards because it had the ability to create the machine of local government. And part of creating the machine of local government, a gear or a sprocket of that machine, I guess you could say, is something like a local public works board. If you hear that Cooley ultimately ended up saying the state could do what it wants in regards to these local boards, and you ask, wait, he just spent so much time talking about how local governments have independent historical existence, and how state and local governments are separate spheres, and how there are these unstated background principles in state constitutional law that create this space for local autonomy. How could he say all these things and then end up ultimately siding with the state? Believe me, I'm asking the same questions. But before we go on to analyze and critique Cooley's concurrence, let's wrap up with a bit more about Cooley himself and how history has understood his doctrine. I also am just excited to talk more about his background because I think Cooley's a cool dude. First, some biographical background about Cooley. It's not surprising that Judge Cooley wrote this long concurrence about the structure of local versus state government and the limits of state authority. And it's also not surprising that he drew so strongly from de Tocqueville, because Cooley was fascinated by these kinds of questions. In his 20s, Cooley paid keen attention to the European revolutions in 1848, which were these revolutionary movements, not all of them successful, that involved an uneasy alliance between middle-class intellectuals and working-class advocates who were rebelling against European monarchical institutions. Uprisings occurred in Ireland, France, Italy, Poland, the Netherlands, and many other European countries. We don't have time to get into the details of each of these revolutions, but to paint with a very broad brush, they often centered on questions of central versus local authority and of overreach by central powers that were seen as corrupt or unrepresentative or unresponsive to ordinary people. Cooley wrote poems praising these 1848 revolutions, or at least that's what Wikipedia says. I couldn't track down any of these poems myself, unfortunately. If any of you happen to know where I can find some of Judge Cooley's poems, please do let me know. I'd love to read them. At the same time that Judge Cooley was paying attention to all these developments in Europe, he was also writing poems criticizing slavery. Again, at least that's what Wikipedia alleges. He was a founding member of the Free Soil Party, which was an abolitionist breakaway party from the Democratic and Whig parties. The Democrats and Whigs were refusing to rule out extending slavery into territory that the United States had forcibly wrested away during the Mexican-American War. The Free Soil Party's goal was to keep slavery from being legal in any states that might form in that territory. In 1848, former President Martin Van Buren ran as the Free Soil Party's presidential candidate and got 10% of the popular vote, which was, at that time, the best performance by any third-party candidate in American history, and is a lot better than most third-party candidates perform today. Now, all this stuff about writing anti-slavery poems and paying attention to European revolutions happened well before 1871, which is when People v. Hurlbut was decided and Cooley wrote his famous concurrence. And to be clear, Cooley could have become a very different man by 1871 compared to who he was in 1848. He'd joined the Republicans. The party of Lincoln was no longer a part of the Free Soil Party. He'd been elected to the Supreme Court of Michigan, in part because of that Republican Party allegiance. And, in 1871, he was named as the Dean of the University of Michigan. You might say he'd gone a little corporate, but clearly all these ideas and principles he thought over in his youth were still in there somewhere, and they produced his really thoughtful and interesting concurrence in People v. Hurlbut. One more thing about Cooley, because I just can't help it. Despite his Republican Party membership, in 1884 he decided to support the Democratic candidate for president rather than the Republican candidate, because he was not impressed with the Republican candidate's history of being corrupt. This made him part of a group called the Mugwumps, so a pretty independent guy even in his older age. Okay, back to the concurrence. Now, some read Cooley as essentially just laying out the basis for home rule, and specifically the kind of home rule that gives localities inherent authority over matters of local concern, while reserving authority to the state to handle matters of statewide concern. We talked a lot about this kind of home rule in the last episode. I think that view is consistent with some of the stuff Cooley says. In fact, I think it's the correct reading of how Cooley himself may have understood his doctrine. In a move that further makes him Dylan's rival or alter ego or whatever, Cooley also published a treatise about local government. This treatise was called, bit of a mouthful, A Treatise on the Constitutional Limitations Which Rest Upon the Legislative Power of the States of the American Union. Technically, the treatise as a whole was about state constitutions and had a subsection specifically about local governments. In the subsection, Cooley wrote, "It is axiomatic that the management of purely local affairs belongs to the people concerned, not only because of being their own affairs, but because they will best understand and be most competent to manage them. The continued and permanent existence of local government is, therefore, assumed in all the state constitutions, and is a matter of constitutional right, even when not in terms expressly provided for. It would not be competent to dispense with it by statute. So yeah, translation, purely local matters are an area where the local government can act without interference from the state government. This formulation is what is now known as the Cooley Doctrine, and you can see how it might give birth to or provide a frame for modern home rule doctrine. However, despite the general opinion that the Cooley Doctrine is just a way of laying out home rule, I actually want to suggest that there's quite a bit of daylight between what Cooley wrote down as his doctrine and our modern understanding of home rule. In fact, other than raising the divide between state and local that is also at play in some home rule schemes, the Cooley Doctrine is kind of different from home rule. For one, home rule states are generally home rule states either because A, there's an explicit recognition of such in the state constitution, or B, more rarely, because the state legislature passes a statute that says, okay, we are a home rule state now. That's not what Cooley understands as giving rise to inherent local authority over local affairs. Instead, he's saying that local authority is axiomatic, something that is obviously and apparently true in and of itself. Remember what Cooley said in the People v. Hurlbut concurrence about these background principles in state constitutions. These principles were so fundamental that they didn't even need to be explicitly stated. This is that certain fundamental principles in our general framework of government language that I read before from the treatise. That's kind of what he's getting at here. He's saying that local governments have the authority to manage local affairs even if there is no section of the state constitution or some other law that says so. In other words, even if your state constitution doesn't say local governments get primary authority over local affairs, your local government still has that authority. This is a pretty radical departure from how home rule works today. I mean, if Cooley's doctrine was taken as the basis for how stuff worked between local governments and state governments, you would just wake up one day, you look at your state constitution, you go, there's nothing in there about home rule, but that doesn't matter. Because it's an unstated axiomatic principle that our local government gets the authority to handle local affairs and that it can't be overridden by the state government. That is not at all how home rule works. But Cooley's doctrine actually departs even more strongly from home rule when it says that, quote, the continued and permanent existence of local government is assumed in all state constitutions, can't be gotten rid of, and can't be dispensed with by statute. Remember that in every single state, even home rule states, local governments generally don't get to make themselves. A state government creates it, usually through an act in the state legislature. And because the state government has the power to create local government, it also can destroy it, or amend the local government's charter to change the authority the local government is permitted to wield. That is not how Cooley understands local governments as coming to be. To him, in line with all that historical conversation he did in his concurrence on how local governments in American states predate or coexisted with state governments, local governments instead have an independent and guaranteed existence. That continued existence is a right that is implied by the very nature of the American constitutional system, and they owe this independent existence to a separate source of authority, a separate fiat than the overarching state government. Cooley doesn't say exactly this, but when he says that the state governments cannot dispense with the existence of local government by statute, he's basically saying that state legislatures, all state legislatures, lack the authority to get rid of local governments simply by passing a law. Again, that is very different than even the most radically home rule states. Even in very permissive home rule schemes, it is still almost always the state legislature that is the source or origin of a local government's existence, and because they are the ones that give rise to and create the local government, they're also the ones that can get rid of it, destroy it, by amending the law that created the local government in the first place. And once again, Cooley's idea that local government's existence is permanent and can't be altered by state legislatures appears to be completely independent of whatever might be in a state constitution. This seems to be one of those background principles that were so obvious and straightforward, Cooley said there was no need to put them in state constitutions. That means if you accepted that Cooley was right, you could just wake up and say, we can ignore a law from the state legislature that says we are getting rid of the city of Detroit. Because at the end of the day, the state legislature doesn't have the authority to get rid of a local government. Okay, this is going a bit more out on a limb, but just hear me out for a second. Let's follow a train of thought that Cooley's understanding of local governments as independent existences arguably implies. Why can't the state government pass a law dissolving a local government? Because the local government is an independent existence, and the right of such existence is a right that the state legislature can't interfere with. Why can't it interfere with that right? Because the right derives from a source of authority other than the state legislature, and that source of authority is superior to the state legislature's authority as it relates to local governments. And that source of authority can only be the direct popular sovereignty of the people who live within a local government, of the community. The people exercise this right to create the local government in the first place. Cooley seems to understand this, and that's why he took great pains to point out that local governments didn't owe their existences to state governments. So wait, the state legislature can't destroy a local government because it isn't the authority that created it. The people are the authority who created it. Does that mean that Cooley understands the people, not the state government, as being the ones who initially give birth to a local government? This might seem like a sort of weird distinction to draw, but remember the case of Oregon? Oregon is, to my knowledge, the one state in the union that makes creation of local government a right of the people rather than falling to the state legislature. And because the people get to create a local government, which really just means get to write and amend its charter, and the charter sets out the description of what the local government can and cannot do, it's actually the people, those living in the community that the local government governs, who get to say what the local government can and cannot do. It's the people who get to say what the scope of their local government's authority is. In summary, by saying that local governments have an independent existence and that they can't be gotten rid of by statute, is Cooley also implying that communities have the inherent authority to create local governments and set the scope of their powers? And that this right is implicitly recognized in every state constitution without the need for an explicit provision saying so? But despite this kind of plausible-sounding theory, what do we make of the fact that Cooley said in his concurrence that state legislatures had the right to confer and recall corporate power, and that the right in the state is a right not to run and operate the machinery of local government, to provide for and put it in motion? That seems to indicate that Cooley didn't understand local governments as being created via an exercise of local popular sovereignty, but instead, as in the traditional Home Rule Doctrine and the Dillon Rule Doctrine, via some action of the state government that builds the machinery of local government. So the Cooley Doctrine lets state governments create local governments, presumably via statute, but then once they exist, they have an independent sovereignty that keeps them from being destroyed or removed by the state? That's consistent with what Cooley said, but it doesn't seem to be a principle that makes a lot of sense. I don't know about you, but it seems like there is some tension between the idea, which is stated in the dissent, the state legislatures create the machinery of local government, and the statements in Cooley's treatise that lie out the Cooley Doctrine, that local governments have a continued and permanent right of existence, and that such existence can't be dispensed with via state legislature statute. Okay, but putting that tension to the side, there's no doubt that the Cooley Doctrine does say that local government can't be gotten rid of via statute from the state legislature. Putting aside the question of what this means about how Cooley understands local governments as being created, we now can sum up a few apparent differences between the Cooley Doctrine and Home Rule. In short, Home Rule says if our state constitution says so, then local governments get to handle local stuff. The Cooley Doctrine says local governments get to handle local stuff without the state interfering, regardless of whether the state constitution says so. Also, the state legislature can't get rid of local governments. That is a pretty damn different view of the scope of local authority, popular self-governance, and the whole American system of government than it's accepted really anywhere in America. If the Cooley Doctrine was the accepted theory, then overnight every American state would have inherent and non-preemptible, at least at the state level, authority over local matters. This probably won't surprise you given what this podcast has been about so far, but I actually think a world where the Cooley Doctrine applied everywhere would be superior than the system we currently have. It would be better than the Dillon Rule and be better than Home Rule. And you know what? I'm actually going to go further. I think that the Cooley Doctrine, while better and more respectful of local agency than the Dillon Rule or Home Rule, actually is ultimately unsound. it's not enough. And I think that's the case because it fails to properly follow the really excellent ideas and principles that Cooley draws out in the People v. Hurlbut concurrence. And that if you take a harder look at those principles, a different rule, a better rule, emerges. Here's what I think Cooley got right. It's ludicrous to suggest that local government should exist only by fiat of the state government. The legitimate source of their authority is, of course, the people who actually live in the area the local government governs, the constituents, the citizens, you, your neighbors, your family, the people in the neighborhood. Local governments receive their legitimacy as a result of an exercise of your popular sovereignty, of the popular sovereignty of those who the local government serves. These citizens come together, determine that having a shared form of government to manage important issues in the community is to everyone's benefit, and then they exercise their inherent rights of self-determination to give that shared form of government practical and political effect. This may seem like a bunch of fancy and convenient theorizing, but it's really not. The idea that our governments exist due to a direct exercise of popular sovereignty is a basic assumption of the American political system. The states ostensibly have their authority because all of the state citizens exercise their inherent sovereignty to give state governments legitimacy. The federal government ostensibly has its authority because the states, exercising the portion of sovereignty granted to them by the people, delegated a portion of that portion to an even higher level of government. If you want to put all the abstract stuff about delegation to the side, you could say that the federal government got its power in the same way as the states. The citizens lived within a shared physical territory. They had an inherent right to govern themselves, but they decided to give up some of their inherent rights by delegating power to a higher body that would then manage affairs to everyone's benefit who live within that contiguous federal territory. So states are born from a direct exercise of popular sovereignty. America as a country was born from the direct exercise of popular sovereignty. So how is it that local governments are somehow a special outlier that everyone pretends have no claim to authority, pretends exist because there's something handed down from on high, rather than the most obvious conclusion, the one that is consistent with how we understand every other level of government, which is that local governments get their power from the people who live in them. Local governments are just like state and federal governments. They obtain their power directly from the people. So if local governments are brought into existence directly by the people, then Cooley was exactly right to say that they have a right of existence that cannot be abridged by the state government. The state government wasn't the source of local government's legitimacy in the first place, so it can't get rid of the local government by statute or other state-level action. I also agree with Cooley that there are certain spheres where local government should be able to act, 1, of its own accord, and 2, without the interference or restraint of a higher level of government. If the source of local government's legitimacy and authority is ultimately the same as the state or even the federal government's authority, direct exercise of personal political sovereignty, then it is simply not the case that local governments are trumped by state governments because state governments made them. Instead, local, state, and the federal government must have been created to attend to particular tasks or subject areas. And so long as local government is working within that scope, within those appropriate subject areas, then it would be an improper violation of the American constitutional and governmental system for state or even federal governments to try and interfere with local actions in that realm. Now, what exactly that scope of local authority should be, what the respective realms that federal, state, and local government should each be acting in is still unclear. And as I'll discuss in a bit, I disagree with Cooley that it's essentially local concern and statewide concern and, let's say, federal concern boxes. But I do agree with Cooley's overall idea that there's this realm within which local governments can act of their own accord without requiring pre-authorization from the state, and where, if a local government is acting within that realm, its actions cannot be interfered with by other levels of government. My theory for why that is different than Cooley's. My theory is because local governments have this inherent authority because it was directly granted to them by the people who live in a local government. But we do agree on that basic theory. So what do I disagree with Cooley on? My biggest problem is with his statement in the Hurlbut Concurrence to the effect that states put the machine of local government into motion and then the local government's constituents operate that machine. In other words, I disagree with Cooley that local government owes its initial existence to some act of creation or incorporation by the state government. Or, okay, let me be a little bit more specific on that. Judge Cooley's description of local authority is that it's a model where the state government puts the machinery of local government into place, but leaves that machinery to be operated by the community that the local government serves. I don't disagree that as like a matter of historical fact. This is largely how local government in America works. Like, literally, if you go and see how local governments were created, it's some law in the state legislature that claims to be creating the local government, and that leads to a local government coming around. Like, that's a historical fact. I'm not contesting that. What I disagree with is that this is how local authority should work in America, and that this is how we should understand local governments as being created. It's a bit of ethical and political wishing than me saying, actually, everyone has the history wrong, and there's never been a case where a state passed a law to create a local government. That's obviously not true. What I disagree with Cooley over is how local authority should work in America. How we should think about the relationship between local governments and state governments. If I was the one who got to make the decision, the machinery of local government, this is the stuff like what's in a local government's charter, what are the procedures of its local legislatures, what public bodies are a part of the local government, and the actual operation of that machine, that would be everything from what laws local government passes to the day-to-day workings of stuff like the fire department. Both of those should flow from the local community. In my view, the way a legitimate local government comes into existence and receives its authority is not because the state might have handed down a charter or other instructions from on high. You got to remember, the way a state legislature works, your area that you live in, which is probably kind of contiguous with your local government, but might not necessarily be, just gets a couple representatives in the state legislature. So if we accept that it's really the state legislature who creates your local government, then what we're accepting is that all of these delegates from all over the state, of which your state legislature delegates are a very small proportion, that all of these other delegates are the ones who really have the say on whether or not your local government is legitimate and are the ones who really infuse it with power. That just doesn't make any sense. It's like saying the reason local governments have legitimacy is because of everyone else, other than the people who actually live in them, who elected these officials who went and passed a law that became the charter. That just doesn't make any sense. Instead, it's obvious and consistent with how we understand the states as having their authority and the federal government as having their authority, that really the way that a local government becomes legitimate is by the exercise of the popular sovereignty of the people who live in the community that the local government governs. And if we accept that, then it's also obvious that the way that a local government is created is through this act of delegation by the people who live in the relevant community. The citizens in that community decide to delegate a bit of their inherent rights of self-government to a local body to manage community affairs. Accordingly, the local government's entire existence originates in the people of the community. And since the people of the community are the ones who create the local government, they naturally should have the ability to shape and manage both the machinery of local government as well as how that machine is operated. If you're on board with my view of legitimate government as being a function of consent and delegation by the governed, then I think this is really the only understanding of local government that makes any sense. I think Cooley was flirting with this model when he talked in his concurrence about how local governments either pre-existed or coexisted with state governments, and with his waxing poetic about local autonomy. But in the end, despite his clear passion for local authority and interest in challenging the now accepted contention that local governments are little more than subservient creations of state governments with no inherent sovereignty, he just didn't draw out those threads to a bolder conclusion. My second point of real disagreement with Cooley's doctrine is the scope he sets on local government's inherent authority. As I mentioned earlier, I do agree with Cooley's idea that there is an area of inherent authority where local governments can act with impunity, without pre-authorization, and cannot be overridden by the state government. I would just draw the circle of that other governments keep out zone bigger than Cooley does. Again, to be clear, I'm not saying that Cooley is wrong as a matter of historical record. It is generally true that in the few states that recognize some amount of inherent authority for local governments, that inherent authority extends only to matters of local concern, whatever the hell that is. What I'm saying is that I don't think that's the way it should work. That I don't think that's how we should draw the circle around the zone of other governments keep out. Instead, I want to propose two alternative models for how we should draw the circle around that zone. Both of these models would represent pretty significant departures from anything that's present in America today. And they would also represent a pretty significant departure from anything Cooley ever raised or suggested. But, while both of them are significant departures, one of the models I'm going to discuss is more radical than the other. I call the more extreme version the absolute model, an admittedly biased and pragmatically unlikely model for inherent local authority that I nevertheless find myself drawn to because I'm a zealot for local action and on-the-ground agency. I call the second and more realistic alternative the reformist model, a line drawing of inherent local authority that flows more directly from basic constitutional or foundational principles of American government and would increase the scope of local authority by a more measured degree. So what are the absolute model and pragmatic model that I'm offering as the way local authority should work in America? How big is the keep-out zone in the two models? And how do they differ from each other? Well, you'll have to wait until next episode to find out. This one's already gone on long enough. But even though the two models are a bit different in the details, they are sort of based on some similar ideas. These are ideas that I brought up again and again in this episode and previously in the show. So to prepare for next episode, where I'm going to lay out both the absolute model and the reformist model in detail, I'm going to tee up the ideological underpinnings now, before we end the episode. First, as mentioned before, my view is that the most legitimate governments are the ones that are closest and most responsive to the citizens they serve. There is no level of American government closer and more responsive to the average person than local government, and accordingly, local government is the most legitimate level of American government. Despite that, it has the least amount of power of any level of American government. Rather than the current system of local governments being doubly dominated by both state and federal preemption, isn't it more logically consistent to give local governments a greater degree of authority than other levels? That broadened scope of inherent authority is earned by and arises from local government's closeness and responsiveness, and the fact that they are created by the most direct delegation of personal sovereignty. It's immediate. The people who live in the community directly delegate their personal sovereignty to the government that they live within. The tagline of the show that I say at the beginning of every episode is that we should ask if we're putting our power in the right places. Shouldn't we be putting the authority to make important decisions in the hands of the local government, which is as close as we can get to putting it in our own hands? It's certainly a lot closer than giving that kind of power to other levels of government, to a state legislature that is full of representatives elected by people across the state, so that everyone except you gets a say on what laws control your local community. And it's also better than giving that kind of power to a federal government that might be hundreds or thousands of miles away from where you live, and that allows people who have no idea what it's like to live where you live and have never met you and don't know the problems you face to make the ultimate decision about what laws you need to obey and how to resolve problems. So that's the first principle that's going to underlie both the absolutist and reformist models. That local government is the most legitimate form of government, so it should be the form of government that has a lot of power. The second ideological underpinning has to do with all the stuff we talked about on how the story or conceit for why the federal government has its authority came to be. In brief, to reiterate for like the millionth time, I'm sure you're tired of hearing it, the idea of why the federal government has its power is that the states get their authority from the American people that reside within them. The citizens delegate some of their inherent right of self-governance to the states. The states, at the time of the nation's founding, then perform a second delegation. They take some of the powers that people gave them and hand them off to the federal government. We know this is the story because the 10th Amendment of the Constitution's Bill of Rights says that any power that's not delegated to the federal government still resides in the states and the people. The story makes complete sense. Of course, no government could exist without some kind of delegation of power from the people. My question is, why is it that American law and history has refused to acknowledge the applicability of this same framework to the relationship between state and local governments? The most straightforward and logical way to understand how states get their powers is that they are Americas in miniature. As state citizens delegated certain powers to their immediate governments, their local governments, and those local governments then performed a second delegation, banding together to give a state government a portion of the power local governments were given by their citizens. This is the principle of legitimacy we ascribed to the literal American nation. Why wouldn't it also be the legitimating conceit for the nation states? Now, some of you might be saying, wait a minute, the idea that the federal government exists due to delegations from states makes sense, because there were states that predated the federal government in the form of the 13 colonies. Most people live in the jurisdiction of local governments that, as a matter of historical fact, came into existence after the states, not before them. Many times, the state is saying, and is legally treated as, if it created the local government. How can it be that we should understand local governments as creating the states instead of the other way around? I have a couple answers for that. It's certainly true that the conventional understanding of law in America is that states are the legal creators of local governments, but that doesn't need to be the case. Again, I'm not saying this isn't historically how stuff worked, that it hasn't historically been the case that state governments give rise to local governments. What I'm saying is that shouldn't be the way we understand it, that isn't the right system, and I would like to do something else. And we can do something else. The law can and should be changed, as can our understanding of how states and local governments should relate to each other. How exactly we might achieve potential changes in law, the changes in law that are needed for both the absolute model and the reformist model of local authority, that's something we're going to cover in depth in future episodes. And let's remember an important fact about how this framework functions at the federal level. Sure, it might be true that a lot or even most local governments actually came around after the states were created. Judge Cooley did a good job of discussing the historical record on why that may not actually be right, and a lot of local governments may have predated state governments, but sure, let's just accept for the sake of argument that it's mostly states getting created first and then local governments second. Isn't that true for America as well? Didn't the overarching federal government predate the vast majority of states? America's borders have spread far wider than the original 13 colonies. All of those new states weren't around when the Constitution was written and the 10th Amendment put into place. In fact, since new states are admitted into the Union via congressional processes, you could sort of fudge it and say that those new states were created by the federal government, rather than the other way around. And yet the 10th Amendment applies equally to both the original states, those that came from the original 13 colonies, and all the ones that came after, even way after. The federal government's power is treated as emanating from delegations from all American states, regardless of whether the states were actually around during the original delegation, the original creation of the nation. Why? Because whatever the facts or history surrounding how most states came about may be, we recognize the justice and the good sense of the principle that all powers not delegated to the federal government remain with the states and with the people. So we act like all American states were there from the beginning, and all states had a role to play in creating the nation. And if we can do that on the national level, there's no reason we can't treat local governments as having given rise to state governments via delegations of power, even if that doesn't 100% match with the facts of history. So, okay, first principle, local governments are the most legitimate forms of government, so they should have the most authority. And second principle, the relationship between local governments and state governments is essentially like that between the states and the federal government. Local governments delegated power to the state governments and were the ones that gave rise to state governments rather than the other way around. Okay, that was a lot of talking about Judge Cooley's law and an old concurrence from an 1871 case that's little more than a what if, and that is, to my knowledge, never actually been adopted as the rule of anything anywhere in America. And I'm sure you're sick of hearing the words legitimate and delegation and all that other stuff by now. Let's call it here for the day. Next time, I stop playing footsies and start actually offering alternatives. I'll go into what the absolute model and the reformist model are, and more than that, I'll try to pitch you an everyday vision of how those alternatives will work, and what it would like to be to participate in the change systems as a part of your everyday life. See you then. If that sounds interesting, think about following the show on Spotify, or shoot me a question at localistpod@gmail.com. That's localistpod@gmail.com. A huge thank you to Kevin MacLeod for letting me use the 2 songs in this podcast, Acid Jazz and Opportunity Walks. You can find these and a bunch of other really great songs on Kevin's website, incompetech.com. And the use of Kevin's music here is licensed under Creative Commons by Attribution 4.0.